And to further elaborate on this matter, we like to invite Ajahn Veerapat Pariyawong into the line, the independent law academic. Good evening.
Good evening.
Good evening, Kapun Jaravi. Good evening, Kapun Vichitra.
Good evening. Thank you for joining us once again. Now, Nitirat wanted the Section 112 to be removed from the national security category, which will turn the amended version turn into the defamation with additional offenses to honor the king and the repute. What is your thought on this?
I think this is a very sharp question. When we talk about the Nitirat proposal, I think most of the people who are in support of Nitirat would think for the first instance that this proposal is for advancing the cause of liberty, the cause of freedom of speech in the Thai society. And those people who are against Nitirat would have to advance their arguments in the way that this is something towards the hidden agenda of trying to violate the sacred, the sanctity of the monarchy institution in Thailand, something that is trying to aim for political purposes beyond the actual proposal itself. Well, your question simply turns those people on the reverse sides of the argument, because if we look at Nitirat's proposal today, we are seeing that in a way, I'm saying this in a way, theoretically speaking as a lawyer, Nitirat is trying to make the offense something more personal, something less public-oriented. The current Section 112 concerns national security, not because any act that defames or insults the king, the queen, or the regent constitutes automatically national security, but those offenses would be considered offense under Section 112 only, in my opinion, if it amounts to a threat or something that affects national security. But if you move the provision, if you repeal this provision, you cancel it, and you create a new provision according to the proposal by Nitirat, and make it something more personal, something that Nitirat calls the reputation of the king, or the honor of the king, or the queen, or the heir apparent, or the regent, I think this is something that we move to as something more personal. So we have to bear in mind the two totally different concepts of law. One, we are talking about something so serious that if you have to be punished for this, you need to be doing it so seriously enough that it affects the national security of the kingdom. But if you're moving to something that Nitirat is proposing, what you might be punished for, what you might be, your actions that constitutes the crime might no longer have to be something that so serious enough that affects national security. It could be something such as a general insult that affects the honor, the reputation of the king and the queen. And if those people who have been supporting Nitirat, I think they have to think very seriously whether this proposal is actually advancing the cause of liberty and freedom that they are thinking that they are doing. And the people who are against Nitirat, who thought that Nitirat is not respecting the king, the queen, and the monarchy, should rethink as well, because in a way, the proposal by Nitirat is actually making it more personal, making it easier theoretically to bring a case against people. Of course, I'm saying this bearing in mind that Nitirat's proposal also contains the exemption from the offense or the exemption from punishment. But those exemptions concerns the good faith public discussions, the academic discussions, or the discussions that would promote and secure democratic democracy with the king as the head of the state. So that's a very narrow and still, to me, a very new territory for us to go into and define what is good faith discussions of the king's role, what is good faith discussions of the role of the monarchy in Thailand. What we have now today is Section 112 that represents the offense in the category in a way that it has to be about national security. The solution, the proposal, the counter proposal, I would say, that I would like to propose to the audience tonight is, instead of moving the Section 112 out of the national security category, we should insert extra provision, additional provision that would clarify the interpretation and the enforcement of the whole category. Make Section 12 exclusively about something so serious enough that it affects national security, not something so trivial that would be rounded up as anything that relates to national security.
I see.
And earlier we've tried to contact Professor Warajed to ask him about the concerning matters that we've been discussing earlier. And he said that the draft that he proposed, that Nitirat proposed, has already indicated that the office of His Majesty's Principal Private Secretary can only be the one to file the complaint. Now, is this point making it any better from, the concerns that we've been talking about earlier?
Right. I have great respect for Professor Dr. Warajed and his colleagues, and I admire the bravery. Although I might not be in total agreement with the proposals they make on several fronts, I certainly admire them as academics. I have to say that I have no principal objections against the idea that we change what we call accusatory authority, or in layman's term, the people who can press charges, who can bring criminal case against the people who might be committing offense against the king or the queen. I have no principal objections against that. But again, we have to think about this very carefully. Nitirat is trying to say that this is not just one proposal proposed one time and that's it. I think Nitirat made it very clear. Professor Dr. Warajed himself made it very clear in his speech he gave yesterday that this is just the first step towards the greater, the broader revolution, the not revolution, would say the improvements of the systematic improvements of the institution and of the legal system in Thailand. So if on one hand this proposal by Nitirat is making it less politicized for someone to bring cases against anyone, I think that's a good thing. But it does not take away the fact that by moving Section 112 out of the national security category and instituting a new category, making it a very personal offense, the honor and reputation of the king, that actually goes against the very spirit of liberty and freedom of speech that Nitirat is arguing for. Because we have to remember, Kun Vichitran, when we're talking about public figures in Thai society, prime ministers, presidents, or even highest ranking members of the religious clans, the people have concerns and they talk about them, they criticize them, they question them, and they admire them at the same time. Nitirat has to be very careful. If you're creating something new that has not existed before, that is the provision that protects the reputation, the honor of the king, making it so personal instead of a public security matter, even if you make it difficult for someone to press charges, even if you decrease the penalty from maximum 5 years to maximum 2 years, the rationale, the entire philosophy behind the movement is rendered moot, in my opinion.
Right. How longer do you think that, even though if they propose this to the Constitution, how longer will it take, the process? Well, we'll still have time to talk about this, right?
I think the Nitirat and the Corridor 112, or the committee that is spearheading the amendment of Section 112 is not moving this proposal together with the constitutional amendment. I think they are moving this towards its own exclusive amendment, that is to gather 10,000 names of registered of the eligible voters, and then submit the proposal of this draft amendment to the Parliament. There will be challenges by members of the Parliament whether this proposal should be accepted or not in the first place, and if it is indeed accepted, there will be several processes. The first one would have to be whether they will look at the draft and set up committees to consider the drafts. The Nitirat and the people who propose the drafts, the general citizens of Thailand who sign among the 10,000 plus people, would have the opportunity to explain to the Parliament the reasons why they propose this amendment to the criminal code. So I think, democratic-wise, I think it's a positive thing in terms of process, in terms of creating a positive democratic environment among the people under the law. This is not something that we go out and burn buildings. This is something that we do it with rationale, with reasons. And I think what is worrying me is the fact that those people who are against Nitirat are very weak in terms of their rationale. If you look at the Democrats' Party, today. I'm very disappointed by the rationale proposed by Kun Chawanon. The reasons proposed simply to attack the hidden agenda of Nitirat itself, but not the legal rationale behind the moving of the Section 12 out of national security into something more personal, which is in a way is in itself a rebuttal against the Democrats Party, because Nitirat is making the offense more personal, more down to earth, something that is anyone can feel that their honor or their reputation is being offended. The same holds true for the king, the queen, the heir apparent, or the regent.
Weerapat Parayawong, thank you so much once again for taking your time talking to us.
My pleasure always. Thank you, Kap.